Dave?
Thank you, sir. The plants and animals deserve legal ground to stand on. About a dozen communities around the country have adopted ordinances that will help give legal rights to birds, bees, and even trees. Seriously. Joining us with both sides, First Amendment attorney and author Mark Harold and trial attorney Herb Subin. Good morning to both of you, gentlemen.
Good morning.
Good morning.
Mr. Subin, seriously? I mean, explain this to me. Explain the concept for viewers at home that are still scratching their heads going, what?
Well, you know, we as society have a right to try and use our natural resources to help preserve all of our liberties. I don't take the tack that it's the trees that has the right. I think it's all of society's rights to enjoy the benefits of our resources that allow us to exist.
Interesting. All right, so some examples we mentioned. Communities adopting measures to give nature legal standing. In Pittsburgh, there's a community that banned natural gas drilling within city limits. In Mount Shasta City, California, trying to block cloud seeding. This is, again, seriously. Mark Harold, what do you think about this idea?
Well, it's not a new idea. It's been around for a while. It came from a law review article, at least that's where it stemmed from back in the early 70s. The main problem here isn't necessarily whether this could be done, but it can't be done at the municipal level. The EPA exists, federal regulation exists for corporate actors and for any kind of offense to nature, this sort of thing. So the bottom line here is this is going to be preempted. If these municipalities act and pass these laws, it's going to be preempted by federal law, preempted by state law. There's a chance, I guess, that this type of standing could be achieved, but not at the municipal level. So I don't think this is going to gain much ground.
Herb, just imagine the can of worms that you open up here. Who has the right to sue on behalf of said bees, trees, and clouds?
Well, that's a really interesting legal issue as to who's going to have the standing to bring these actions. And I do agree that I don't think at the local level you're going to be able to bring these actions. It is a federal right to deal with this on a federal level. But I really think that the concepts are great concepts because the private sector's always done a really good job of affecting social change. You look at the school board change and desegregation. So you always have really good use of the courts to try and help affect positive social change.
But Mark, most of these are having trouble even getting past the local level. You give this no chance at going to a national level and spreading throughout the country?
Well, I don't think so, especially not coming from these local lawsuits where the standing is statutory and it's municipal. You know, as far as the social change, it would have to be achieved, like we said, at a much higher level. The other types of things we talked about with Brown v. Board and other types of social change, whether it's the 19th Amendment and women's right to vote, whether it's the 14th Amendment and racial equality, these things went all the way to the constitutional level, and then the courts interpreted them backwards after those were passed. I don't see it happening this way with the lawsuits first.
Mark Harold, Herb Subin, seriously, thank you for being here this morning.
Thank you.
Come on.